5 seconds. Start. The revenue being aggrieved by the decision of the board filed tax revision petition before the High Court under Section 86(2) of the Act. The High Court dismissed the revision petition filed by the revenue and upheld the decision of the board by holding that the respondent unit is a prestigious unit and therefore entitled to 75% tax exemptions under the scheme. Aggrieved by the order so passed by the High Court, the revenue is before us in this appeal. We have heard learned counsel for the parties to the case and perused the documents on record as well as the order passed by the authorities and the High Court respectively. The learned senior counsel appearing for the appellant submits that the case pleaded by respondent unit right from the beginning of filing the application before the state level screening committee was that the new unit had made an investment of more than rupees 500 crores by way of fixed capital assets and therefore they should be placed under the category of prestigious unit and accordingly be granted eligibility certificate to claim 75% of exemption from tax for the maximum time limit provided under the scheme. In aid of this submission, the learned senior counsel would draw our attention to the application and the accompanying affidavit filed by the respondent unit before the state level screening committee. He would further contend that the respondent unit before all the authorities below, excluding the High Court, had adopted the stand that the fixed capital investment, excluding investment made before 5th March 1997, was more than rupees 530 crores and therefore the respondent unit is a prestigious unit entitled to an exemption of 75% of total tax liability. It is further contended that the respondent new unit being new cement unit and further being large scale unit though can avail the benefit of the incentive scheme under 1E of Annexure C, which provides for exemption up to 25% of total liabilities. It cannot avail the benefit of exemption at the rate of 75% under item 4 as prestigious unit. He would further submit that benefit to cement industry is confined to the extent envisaged under the item 1E of Annexure C, as the said item is a specific provision relating to cement industry.